All right, we will. The International Criminal Court is now in session. Lord Joint Court Panel International to it. Please be seated. Veuillez-vous asseoir.
Good afternoon, everyone. Court officer, please call the case.
Good afternoon, Mr. President, Your Honors. This is the situation in the Democratic Republic of Congo in the case of the prosecutor versus Bosco Ntaganda, case reference ICC 0104 0206, and for the record, we're in open session.
Thank you, court officer. I welcome everyone to this hearing. Before we commence, I would like to welcome Mr. Bosco Ntaganda and his counsel, Mr. Stefan Bourgon and Ms. Kate Gibson, who are attending this hearing remotely as provided for in the scheduling order. I'd also like to thank the registry staff for securing their attendance through the use of video technology. I thank everyone as well for cooperating in ensuring the efficient conduct of the proceedings in this case. I'd like to ask now the legal representatives of victims, the defense team for Mr. Ntaganda, the representatives of the VPRS and the registry, the office of the prosecutor, and the trust fund for victims to introduce themselves and their teams for the record, please. Legal representative victims first.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par Caroline Walter et par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Good afternoon, Mr. President. Your Honor, the victims of the attacks are represented by myself, Dmitry Supron, counsel and also public counsel for victims. Thank you.
Yeah, defense team, please.
Good afternoon, Your Honors. As you noted, Mr. Bosco Ntaganda is appearing remotely today via video link and is represented by lead counsel, Mr. Stefan Bourgon, appearing from Quebec remotely as well. Co-counsel, Ms. Kate Gibson, appearing from Switzerland remotely as well. And present in court today are case manager Benjamin Willam and myself, Jacopo Ricci, legal assistant. Thank you.
Thank you. And VPRS?
Good afternoon, Mr. President, Your Honors, for VPRS and the registry today, my colleague Rafael Gomez and myself, Philipp Ambach. Thank you.
Thank you. Prosecution?
Bonjour Monsieur le Président, Monsieur, Madame les juges. Mon nom est Marion Rabani et je représente le procureur aujourd'hui.
Thank you. Trust Fund for Victims, please.
Good afternoon, Your Honors. My name is Deborah Ruiz Verduzco. I am the Executive Director of the Trust Fund for Victims, and I'm here with three members of the legal team of the Trust Fund for Victims, Franziska Eckelmans, Michele Gagliardini, and Nicole Richter-Stark. Thank you.
Thank you. Present at this hearing are also the judges of the Trial Chamber 2. I am Judge Chang-Ho Chong, President of the Chamber. To my right is Judge Peter Kovace, and to my left is Judge Maria del Socorro Flores Liera. We are accompanied by the members of our legal staff. We gather today for the Chamber to pronounce its addendum to the reparations order in this case, issued on 8 March 2021, which was partially reversed by the judgment of the Appeals Chamber issued on 12 September 2022. As provided for by the Rule 144, Para 1 of the rules, the Chamber delivers a public summary of its main findings and conclusions in the presence of the convicted person, the defense team, the legal representative of victims, and the office of the prosecutor. The Chamber underscores that only the written addendum to the reparations order, which was filed just before this hearing, and will be notified shortly afterwards is authoritative. 1. Introduction. I shall begin today by recalling that the appeal chamber remanded the matter to the chamber as it partially reversed the reparations order, considering that trial chamber 6 failed to 1. Make an appropriate determination in relation to the number of potential eligible or actual victims of the award and or to provide a reasoned decision in relation to its conclusion about that number. 2. Provide an appropriate calculation or set out sufficient reasoning for the amount of the monetary award against Mr. Ntaganda. 3. Assess and rule upon victims' applications for reparations. 4. Lay out at least the most fundamental parameters of a procedure for the Trust Fund for Victims to carry out the eligibility assessment. And 5. Provide reasons in relation to A. The concept of transgenerational harm and the evidentiary guidance to establish such harm. B. The assessment of harm concerning the health center in Sayo and the breaks in the chain of causation when establishing harm caused by the destruction of that health center. And C. The presumption of physical harm for victims of the attacks. As such, the present addendum shall be considered an integral part of the reparations order to be read in conjunction with it and be understood as complementing and replacing therefrom only the specific issues that are dealt with hereafter. The Chamber notes that all parties will have a fresh right to appeal the present addendum as an integral part of the reparations order directly before the appeals chamber pursuant to rules 150 to 153 of the rules. The chamber underlines that reparations proceedings before the ICC are strictly limited in reach and scope to the terms of the conviction. To better illustrate the Chamber's findings and support the eligibility process, the Chamber has detailed in Annex 1 to the addendum the scope of the conviction in relation to the victims of the attacks. 2. Analysis. The Chamber will now summarize its conclusions on the issues on remand. A. Sample of victims' dossiers and the procedure for carrying out of the eligibility assessment of victims at the implementation stage. The Chamber has assessed and ruled upon a sample of victims' dossier composed of 171 victims, which included A. All victims so far found eligible to benefit from the Initial Draft Implementation Plan, or IDIP, by the Trust Fund for Victims, or TFV, and B. A randomly selected group from participating and victims known to the court amounting to 5% of the victims of the attacks and 5% of the victims of crimes against child soldiers. The Chamber found that this sample was sufficiently representative of the universe of potential victims of the case as regards gender, age, and alleged harm, crimes, and locations. As described in the addendum, when ruling on the sample, taking into account the parties' submissions and additional information, the Chamber reached conclusion allowing it to set out the parameters for the future eligibility assessment to be conducted at the implementation stage. To be eligible for reparations victims must provide sufficient proof of identity of the harm suffered and of the causal link between the crime and the harm. Balance of probability is the appropriate standard of proof in reparations, and but for is the standard of causation. It is required that the crimes were the proximate cause of the harm, which includes an assessment as to whether it was reasonably foreseeable that the acts and conduct underlying the conviction would cause the resulting harm. The Chamber elaborates on the specific parameters that must be met in the addendum. Having analyzed the sample on the basis set out in the addendum and as detailed in Annex 2, the Chamber concluded that 132 of the 171 victims in the sample have established on a balance of probability their eligibility as direct or indirect victims of the crimes for which Mr. Ntaganda was convicted, and accordingly are entitled to benefit from reparations in the present case. 10 out of the 132 victims above have been deemed to be provisionally eligible. These victims will be entitled to benefit from reparations for as long as the relevant missing information, as detailed in Annex 2, is provided at the implementation stage. And 39 out of the 171 victims in the sample have not established on a balance of probabilities their eligibility as direct or indirect victims of the crimes for which Mr. Ntaganda was convicted, and are therefore not entitled to benefit from reparations in the present case. As of 67 victims in the sample that are benefiting from the initial draft implementation plan, which are accounted for in the totals referred above, the Chamber found that 59 victims have established their eligibility, 4 victims have been found provisionally eligible, and 4 victims have not established their eligibility. All victims that have not established their eligibility will have the opportunity to supplement their dossiers and clarify their accounts at the implementation stage. B. Issues related to transgenerational harm. In light of the findings of the Appeals Chamber, the Chamber detailed its reasoning regarding both the concept and the evidentiary criteria required to prove transgenerational harm. First, the Chamber concluded that experts from different disciplines do agree on the existence of the phenomenon of transgenerational harm. This conclusion was reached after having assessed the jurisprudence of the court, the scientific and academic literature referred to by the parties and participants, and by taking into account the evidence provided by other experts in other proceedings before the court, as well as decisions issued by other international jurisdictions. The Chamber also considered the different theories and the current state of the scientific debate as to the way transgenerational harm is transmitted, which in the Chamber's view simply reinforces the existence of the phenomenon. As to the evidentiary criteria to prove transgenerational harm, the Chamber indicated that a child of a direct victim claiming to have suffered transgenerational harm would generally need to prove the following. 1. That a direct victim suffered harm as a result of a crime for which Mr. Ntaganda was convicted. 2. that the child of the direct victim suffered harm. 3. That the child's harm arises out of the harm suffered by the direct victim, the causal link, and 4. The parent-child relationship. As to the evidence required to prove the elements above, the Chamber considers that the same evidentiary criteria that is applicable in order to prove identity, harm suffered, and the causal link between the crime and the harm, as for any other victims in the case, applies to the victims claiming transgenerational harm. The Chamber provides further detailed guidance with regard to each of these 4 points in the addendum, noting that although no presumption of transgenerational harm applies, the general factual presumptions established in the Reparations Order, to the extent that are not affected by the Appeals Chamber judgment, still apply. The Chamber further reiterated that it was appropriate to award reparations for transgenerational harm in this case, and that Mr. Ntaganda should be liable to repair this type of harm in the specific context of the crimes for which he was convicted. However, the impact of the protracted armed conflict in the DRC is a matter of evidence that has to be decided on a case-by-case basis as part of the eligibility assessment. Finally, the Chamber found that it is essential to acknowledge the existence of the phenomenon of transgenerational harm and the personal suffering that children of victims of unimaginable atrocities may also experience. In the view of the Chamber, this approach is further justified in light of the fundamental principle of the best interest of the child, which should guide the reparations decisions concerning children while ensuring that the rights of the convicted person are fully respected. C. Issues related to the health center in Sayo. The Chamber first noted that for conviction and sentencing purposes, the nature of the crime of attack against the protected objects, which is a conduct crime as opposed to a result crime, did not require it to make any determination beyond reasonable doubt as to whether harm was actually inflicted as a consequence of the crime. However, at the reparations stage of the proceedings, the Chamber may make findings as to the harm inflicted as a consequence of the crimes on a balance of probabilities. Having assessed the evidence and submissions, the Chamber concluded that harm as a consequence of the attack against the health center in Sayo was indeed established, and that the victims include 1. The Sayo Health Center as a legal entity, 2. Individual victims, namely patients that were receiving ongoing in-hospital and ambulatory care at the time of the attack, the health center staff and indirect victims of the above, and 3. Community of Sayo and its surroundings as a whole. The Chamber further details its findings as to the type of harm caused to each of the victims. The Chamber was satisfied that the standard of causation was met on a balance of probabilities, underlying that Mr. Ntaganda's liability is limited to the harm caused as a direct consequence of the crime for which he was convicted. Finally, the Chamber details its reasoning when determining the total amount of Mr. Ntaganda's liability as at $130,000 US. The Chamber concluded that this estimate was the most appropriate indicator under the current circumstances to effectively measure and quantify to the extent possible the harm caused by the attack to the health center and the community as a whole, especially in relation to immaterial harm. D. Presumption of physical harm for the victims of the attacks. In light of the findings of the appeals chamber, the chamber provided its reasoning regarding the scope of the concept of physical harm and assessment of the information available as to the physical harm suffered by the victims of the different crimes committed during the attacks. The chamber first noted that, in its view, the jurisprudence and the legal framework of the court does not restrict the concept of physical harm to the infliction of physical or bodily injury only. The concept is clearly broader in scope in the sense that hurt, pain, or suffering otherwise not caused by a bodily injury can also amount to physical harm. Having assessed the information available in the present case as to the physical harm suffered by the victims of the different crimes committed during the attacks, the chamber concludes that no presumption of physical harm could be reached in relation to Count 11, pillaging, Count 18, destruction of property, Count 3, attack against civilians, and Count 17, attack against protected objects. However, recalling the harsh conditions that the victims of forcible transfer and displacement and persecution through the underlying acts of forcible transfer and displacement had to endure, the chamber maintained the presumption of physical harm for all victims of Count 12 and 13, forcible transfer and displacement, and Count 10, persecution. Lastly, regarding all the other victims of attacks who may have suffered physical harm and who fall outside the scope of the presumption, the chamber recalled that the harm may be established by showing the existence of physical harm and the causal link between the harm and the crimes for which Mr. Ntaganda was convicted. E. Number of potentially eligible victims. In light of the issues on remand, the chamber provided its reasoned conclusions as to the estimated number of potential beneficiaries of reparations based on the submissions made throughout the reparation proceedings, the information and evidence in the case file, and the conclusions that could be reached from the analysis of the sample. Regarding the direct and indirect child soldiers victims, according to the terms of the conviction and sentence, the chamber notes that this group of victims include 1. Overlapping direct and indirect victims between the Ntaganda and Lubanga cases, and 2. The additional Ntaganda-only victims, including A. Child soldiers falling under the temporal scope of the Ntaganda case only, meaning beyond the temporal scope of the Lubanga case. B. Child soldiers who are also victims of sexual and gender-based crimes, and the children born out of rape and sexual slavery against the child soldiers, or SGBV child soldiers victims. And C. Indirect victims of all the above. As for the overlapping direct and indirect victims between the Ntaganda and Lubanga cases, the chamber notes that the final number of beneficiaries found eligible in the Lubanga case amount to 2,476 direct and indirect victims. Having assessed the submissions and information available and interpreting uncertainties in favor of the convicted person, the Chamber concluded that the likelihood of additional overlapping Lubanga Ntaganda victims coming forward in the Ntaganda case and child soldiers victims exceeding the temporal scope of the Lubanga case and their indirect victims coming forward in the Ntaganda case would only be limited to exceptional cases, if at all. Regarding the SGVB child soldiers victims and their indirect victims, the Chamber relied on the result of the sample, which indicated that 1. Approximately 18.2% of the total number of victims found eligible qualify as SGBV victims, and 2. Approximately 20.5% of the total number of victims found eligible qualify as indirect victims. Considering these known values, the Chamber was able to estimate that 1. The potential additional child soldiers, SGBV victims, would amount to approximately 451 additional individuals, 18.2% of 2,476. And 2. Their indirect victims would amount to approximately 92 additional individuals, 20.5 of 451. In light of this, the total number of child soldier victims in the case can be estimated to amount to approximately 3,019 victims. This estimation closely coincides with the conservative estimate of 3,000 victims advanced by the TFV regarding direct and indirect victims who suffered material, psychological, and often physical damage, loss, or injury as a result of these crimes. Accordingly, in light of all considerations above and explicitly resolving uncertainties in favor of the convicted person, the Chamber estimated that the approximate number of direct and indirect victims of crimes against child soldiers in the case as referred to in count 6, 9, 14, 15, and 16 of the conviction judgment would amount to approximately 3,000 individuals in total. Regarding the total number of potential direct and indirect victims of the attacks, as described in details in the addendum, the Chamber assessed the submissions and evidence and determined that it was unable to rely on estimations provided by the common legal representatives tool or the most recent calculations provided by the registry. However, the Chamber took into account the registry's submissions as to the limitations of the preliminary mapping exercise, as it did not consider more than 70% of the population who had not returned. As to the defense submission, that the appropriate way forward would have been for the VPRS to conduct a detailed mapping exercise. The Chamber concludes that the conditions to safely and expeditiously conduct such mapping exercise were not present. Having assessed the remaining information and evidence in the case file, the Chamber concludes that based on the registry preliminary mapping exercise and the information provided by the appointed expert, there was sufficient basis to conclude that at the very least, a minimum of 3,500 direct victims of the attacks will qualify as potential beneficiaries of reparations in the present case. In order to reach a conclusion on the total number of direct and indirect victims of the attacks, the Chamber considered the registry's recent submissions that previous estimations only included potential beneficiaries who resided in or had returned to the relevant localities. Accordingly, the Chamber understood that the previous registry's estimate 2,276 individuals would have corresponded to approximately 30% of the potential victims of the attacks. From that number, the Chamber calculated that 70% purportedly remaining would amount to approximately 5,311 individuals, with the total number of potential direct and indirect victims of the attacks following this reasoning amounting to 7,587 individuals. The Chamber notes that this calculation once again closely coincides with the estimate advanced by the Trust Fund for Victims of approximately 7,500 direct and indirect victims who suffered material, psychological, and possibly physical damage, loss, or injury as a result of these crimes. Accordingly, in light of all considerations above and explicitly resolving uncertainties in favor of the convicted person, the Chamber estimated that the approximate number of direct and indirect victims of the attacks in the case as referred to in counts 1, 2, 3, 4, 5, 7, 8, 10, 11, 12, 13, 17, and 18 of the conviction judgment would amount to approximately 7,500 individuals in total. F. Calculation of the monetary award against Mr. Ntaganda. Having thoroughly and carefully considered the submissions made throughout the reparations proceedings by the parties, participants, and appointed expert, the Chamber reached the following conclusions. 1. Amount required to repair the overlapping victims and harms between the Ntaganda case and the Lubanga case. Mr. Ntaganda and Mr. Lubanga are jointly and severally liable to repair the full extent of the harm caused to the victims of the crimes for which they were both convicted. Only in the event that one of them pays or reimburses to the Trust Fund for Victims, the amount required to provide reparations does the issue of recovering from other co-perpetrators their proportional share arise. Mr. Lubanga's total financial liability for reparations was set at 10 million US dollar. The final number of beneficiaries found eligible in the Lubanga case is 2,476 direct and indirect victims. The TFP has projected that the average cost per capita for a full rehabilitation in the Lubanga case would be approximately 4,000.61 US dollar, direct and indirect costs included. Taking into account these projections, the full rehabilitation of all victims found eligible in the Lubanga case would amount to approximately 9,905,510.36 US dollar. The Chamber considered the fact that the TFP projections were made during the second year of a 5-year program with not all victims yet participating. As such, the average calculated by TFP may not account for an important number of victims requiring expensive mental or physical health support outside the bunya, or the possible impact of inflation or the security situation on the cost of implementation of the service-based program. The Chamber is therefore satisfied that setting the amount of liability of Mr. Ntaganda regarding the overlapping victims and harms with the Lubanga case at the same amount of 10 million US dollar as it was set for Mr. Lubanga is fair, equitable, and appropriately and takes into account the rights of the victims and those of the convicted person. 2. Amount required to repair the additional Ntaganda-only victims of crimes against child soldiers. Having considered the approximate number of direct and indirect victims of crimes against child soldiers would be approximately 3,000 individuals, excluding the Lubanga victims, this subgroup of victims will likely not exceed of 524 victims in total. Following prior jurisprudence in the Reparations order, the Chamber presumed material, physical, and psychological harm regarding former child soldiers, direct victims of rape and sexual slavery, and indirect victims who are close family members of the above. Accordingly, all the victims in this subgroup would, in principle, be entitled to a full rehabilitation program, which, as noted above, is projected to cost, in average, per capita, $4,000.61 US dollar, direct and indirect cost included. Taking these projections into account, the full rehabilitation of the estimated Ntaganda-only victims of crimes against child soldiers would cost approximately $2,096,320 US dollar. 3. Amount required to repair the harms caused to the victims of the attacks. Having assessed the different estimations submitted throughout the proceedings, the Chamber considered that the most reliable estimates at this stage are the calculations recently provided by the TFB regarding the Lubanga case, as they are based on the actual cost of a reparations program designed for victims from the same region affected by the same armed conflict. To ensure fair and equal treatment, all victims should receive equivalent services, even if implemented by different partners. As such, the Chamber considered fair and appropriate to use the Lubanga estimations based on the actual cost of implementations as the basis to calculate the approximate cost of repair and the harms suffered by the victims of the attacks in the Ntaganda case. The Chamber recalls that it has concluded that the victims of the attack would amount to approximately 7,500 individuals in total. The Chamber further notes that the result of the sample assessed by the Chamber provide reliable point of reference to project the calculations of the total cost to repair the different kinds of harm suffered by the victims of the attacks. 1. Cost required to cover measures directed at providing mental care to victims of the attacks. The result of the sample indicates that 100% of the victims of the attacks that were found eligible within the sample are to be considered to have suffered from psychological harm. This calculation coincides with the result of the first year of implementation of the reparations program in the Lubanga case, where 100% of beneficiaries underwent primary mental care. As such, the Chamber considered that it can be safely estimated that similar percentages of victims of the attacks will require secondary and specialized mental care as those required by victims in the first year of implementation of the Lubanga reparation program. In light of this, as detailed and itemized in the addendum, the Chamber estimates that total amount required to provide mental care to victims of the attack in the Ntaganda case would approximately amount to $5,032,898 US. 2. Cost required to cover measures directed at physical care of victims of the attacks. The results of the sample indicate that 43.9% of the victims of the attacks that were found eligible are to be considered to have suffered from physical harm. This calculation is very close and almost coincides with the result of the first year of implementation of the reparations program in the Lubanga case, where 41.77% of beneficiaries underwent primary physical care. As such, the Chamber considered that it can be safely estimated that similar percentages of victims of the attack will require secondary and specialized physical care as those required by the victims in the first year of implementation of Lubanga reparation program. In light of the above, as detailed and itemized in a table included in the addendum, the Chamber estimates that the total amount required to provide physical care to victims of the attack in the Ntaganda case would approximately amount to $2,780,922 US. 3. Cost required to cover measures directed at socio-economic support of victims of the attacks. Regarding socio-economic support, the TFV provided average cost but did not provide statistics as to the number of beneficiaries that have benefited from this component of the service-based reparations program in the Lubanga case. Nevertheless, the result of the sample provide the Chamber with sufficient information to project estimated cost, particularly considering that the results of the sample have been shown to fairly correspond with the result of the first year of implementation of the reparations program in the Lubanga case regarding psychological and physical harm. As to the first component of the measures of socio-economic support quantified by the TFV, education support, not having other parameters allowing the Chamber to estimate with more certainty how many beneficiaries would qualify to receive it, the Chamber decided with its discretion to estimate for the purpose of calculation that all indirect victims would likely qualify to receive schooling support. Noting that according to the result of the sample, 27.6% of the victims of attack would be eligible as indirect victims, the Chamber estimates that the same percentage would likely require schooling support. Regarding vocational training and income-generating activities, IGA, the Chamber considers fair to estimate that all victims that have suffered material harm would likely require to benefit from vocational training and IGA activities. Noting that according to the results of the sample, 76.5% of victims of attacks are to be considered to have suffered material harm. The Chamber estimates that the same percentage of victims in the estimated total of victims of the attack in the Ntaganda case would likely require vocational training and IGA activities. In light of this, as detailed and itemized in the addendum, the Chamber estimates that the total amount required to provide socio-economic support to victims of the attack in the Ntaganda case would approximately amount to 11,189,765 US dollar. 4. Amount required to repair the harm caused as a consequence of the attack to the Sayo Health Center. As described above, the Chamber found Mr. Ntaganda liable to repair the harm caused as a consequence of the attack to the Sayo Health Center, which is estimated regarding the harm to the center and the community in the total of 130,000 US dollar. Regarding individual victims, patients, health center staff, and the indirect victims, the Chamber notes that they are considered above within the general estimation of approximately 7,500 victims of the attacks. No further calculation is required in relation to these victims. 5. Conclusion as to the total amount of Mr. Ntaganda's liability for reparations. In light of the above, as consolidated and itemized in the addendum, the Chamber estimates that the total amount required to provide reparations to all victims of the crimes for which Mr. Ntaganda was convicted would approximately amount to 31,222,905 US dollar. The Chamber considered all parameters underlined by the TFV when projecting the cost based on the Lubanga program and took into account the need to provide for extra costs due to inflation, the financial impact of the ongoing security situation, and the additional victims that may come forward and be found eligible to benefit from reparations. In light of this, the Chamber is satisfied that setting the amount of Mr. Ntaganda's liability for reparations at a total of 31,300,000 US dollar is fair, equitable, and appropriate, and takes into account the rights of the victims and those of the convicted person. G. Implementation of reparations. In line with the Chamber's approach to these proceedings, following this addendum, the Chamber will rule on all aspects of the draft implementation plan that do not require further submissions from the TFP or the parties, including the procedural aspect of the mechanism for the determination of the victim's eligibility. Lastly, the Chamber reiterates that Mr. Ntaganda's conviction is final, and his liability to repair the harm caused to the victims of his crime is under no discussion. As such, the Chamber will continue striving to advance these reparation proceedings in the most efficient and effective manner possible, protecting the rights of the convicted person while ensuring that the victims of his crimes receive the reparations they are entitled to, and for which they have waited for more than 2 decades without further delay. For the foregoing reasons, the Chamber hereby unanimously issue this addendum to the reparations order against Mr. Ntaganda. Finds that 132 out of the 171 victims in the sample have established on a balance of probabilities their eligibility as victims of the crimes for which Mr. Ntaganda was convicted. Find that 39 out of the 171 victims in the sample have not established on a balance of probabilities their eligibility as victim of the crimes for which Mr. Ntaganda was convicted. Reiterate that the victims that have not established their eligibility will have the opportunity to supplement their dossier and clarify their account at the implementation stage. Reiterate its finding in the reparations order as to transgenerational harm. Reiterate its finding in the reparations order as to Mr. Ntaganda's liability to repair the harm caused as a consequence of the attack to Sayo Health Center, which is estimated regarding the harm to the center and the community in the total of $130,000 US. Conclude that no presumption of physical harm shall be applied to victims of Count 3, attack against the civilian population, Count 11, pillaging, Count 17, attack against the protected object, and Count 18, destruction of property. Conclude that the presumption of physical harm for all victims of forced transfer and displacement, Count 12 and 13, and persecution, Count 10, through the underlying act of forcible transfer and displacement should be maintained. Estimate that the approximate number of direct and indirect victims of crimes against child soldiers, as referred to in Count 6, 9, 14, 15, and 16 of the conviction judgment, would amount to approximately 3,000 individuals in total. Estimate that the approximate number of direct and indirect victims of the attacks, as referred to in Count 1, 2, 3, 4, 5, 7, 8, 10, 11, 12, 13, 17, 8, and 18 of the conviction judgment would amount to approximately 7,500 individuals in total. Assesses Mr. Ntaganda's liability for reparation at $31,300,000 US. $31,300,000 US. Reiterate its request for the Presidency's assistance with the support of the Registry to continue exploring whether Mr. Ntaganda possesses any undiscovered assets and to monitor Mr. Ntaganda's financial situations on an ongoing basis. This concludes the Chamber's summary and today's hearing. The Chamber wishes to thank again the interpreters, court reporters, and all other registry staff for facilitating this hearing. This hearing is adjourned.
All rise, we would